Good afternoon, one and all. I hope I'm clearly audible and visible to all.
Yes, you are.
Right. A hearty welcome to all the participants and viewers. I'm Jashaswee Mishra, the moderator for today's session on India's data protection landscape aligning with the GDPR standards. Before I formally introduce you all to the webinar, I would like to request all the participants to join on listen-only mode and to switch off the mic. And for the people who are unable to join us here with the link, they could watch us on YouTube. We are live there on our YouTube channel. A little disclaimer that all the thoughts being expressed by the speakers are very much personal and for the dissemination of knowledge purpose and not to be considered as legal opinion. A brief background of our firm. India Juris is a leading full-service law firm having its offices at Delhi, Bengaluru, Gurgaon, Mumbai, and GIFT City, and a very strong global presence. We have been consistently ranked as number one in private equity and venture capital transaction by the Venture Intelligence. We've also been recognized by the India Business Law Journal as the Law Firm of the Year under the FinTech category. Moving ahead, for today, we have two speakers on board to discuss and to analyze and to further break down for us about the implementation of the Act, which is a much awaited law. Introducing the speakers, we have speaker number one, Mr. Shivram Ganesan, the partner of a firm. He has an experience of over 10 years in corporate matters, advising startups and practicing TMT laws, including data protection laws. He would further today deliberate on the foundational.
You're not audible.
Am I audible now?
Yeah.
Okay. May I please know when was I not audible from?
You can introduce Mr. Shivram Ganeshan.
Right. Uh, Sorry for the technical glitch. Introducing the speakers, we have speaker number one, that is Mr. Shivram Ganesan, the partner of a firm. He has an experience of over 10 years in corporate matters, advising the startups and TMT laws, specifically the data protection laws. He would further deliberate today on the overview and the foundational framework of the DPDP Act and rules. Introducing the speaker number two, we have Mr. Danish Kapoor, who is a risk and compliance analyst and is very passionate about understanding data protection and privacy. He would further deliberate today on the compliances, risk management, and risk assessments, and the practical implications of the Act. Before we deep dive under the presentation, I would like to emphasize why this is the need of the hour to talk about data protection and privacy. As we all are aware that initially data protection was under the Information Technology Act and rules and not as a separate act altogether, right? So it was in 2017 when it was considered as a right, as a fundamental right. So right to privacy was then considered as a fundamental right. And after that, the B.N. Shri Krishna Committee was formed, which gave us many draft bills, such as the Personal Data Protection Bill in 2018. And after that, the 2023 Act came in, and now here we are with the finalization of the Act in November 13, 2025. With this, I would like to invite Mr. Ganesan to the floor to share his thoughts. Please, sir.
Very good afternoon to all, and thanks, Jashaswee, for giving me that sweet introduction about me. Before we start with the presentation, let me candidly say that we have this habit of storing our passwords, or maybe on a platform such as a browser or maybe some social media sites or something, saving our credit cards there. Maybe using something or considering it as a breach once the data is being shared to a third person. We trust a lot of people, hence we do this twin sharing of a OTT platform just to save some cost. With this notion in mind, what we have tried to break down the agenda. Let me know if the screen is visible. Huh?
Yes, it is.
Thank you. So we try to break down the agenda as what would you consider is a data, go with the applicability scope and the timelines of the DPDP Act and the rules framed thereunder. Third aspect is the key parties and the provisions of the acts explained in certain scenarios and questions. We all know that as India is growing, we want international companies to come down to India, but there is always a notion that we don't have the adequate provisions of the act in lines of their home country. This notion from 14th November 2025 would be big news for a lot of people because we do have an act which gives adequate protection to your data. And what would be the timelines or what has been the principle in the GDPRs? Are we aligning with it or are we better than that? So that would be the fourth agenda which we'll like to put a deliberation upon. And the last would be concluding with certain concluding marks. Moving forward with the same, there's a famous line in a lot of movies we see is what is data, right? Data means data is everything. I have a lot of data of a particular person, maybe personal informations, maybe his credit cards, maybe something, what and what not. So what has DPDP Act defined data, right? Data means, as it's defined under 2H, it means a presentation of an information, fact, concept, opinion, instruction in a manner suitable for communication, interpreting, or processing by human beings or an automated means. This is an exhaustive definition. Let's keep that in mind. Now, if someone has to identify who is Shivram, there might be 7, 8, maybe 10 people and around the world. We have this line, "Ek log ke saath naam ho sakte hain," right? Now, with that thing in our mind, how would you distinguish Shivram from another Shivram, right? So that is where my personal information is required to be identified. Now, Section 2T of the Act has defined it means a person who is identifiable by such data. Maybe the 7% or 7 Shivram I'm identifying might not have a same mole in the left hand, which I just have it. Or maybe my some gray hair, I would say that all Shivrams have gray hair, but a person who is a gray hair, but having a mole in his left hand, that is an identification. One way of considering it is to be a personal data, right? Now, the act would apply only to the place where it is in digital in form. So the information which are of a personal in nature that would be to be set as digital personal data is defined under section 2N of the act, which means which is of data in digital form. Now moving ahead with this data thing, there are been categorizing statements being made, and we have made a statement called 3M for data. So what is a 3M? One, data mining. What is data mining? What is data amortization? What is data managing? Now, data uh, mining means sourcing, collecting informations about certain persons, maybe data of a person or data of everyone. Whether the monetization can be of a profit or a loss with that data I'm going to extract. If I am going to extract certain, how am I going to protect and manage and store and etc. Right? That is the 3M for data. Now, moving ahead, let's continue with the aspect of how the DPDP is going to make an effective from this 13th November 2025, right? Certain provisions have already been in place. Certain provisions are going to be effective from a period of 12 months. Certain provisions are going to be fully operationalized by a period of 18 months, which is going to end by May 13, 2027. Uh, Before we get into the timeline, let's understand which data are required to be considered, right? While processing the data, whether it is in India, As I say, Shivram is a person who is a resident of India, considering his PAN card here, having a mole in his left hand. As a third party, will I be able to process that data? The answer is yes. The applicability of the provisions of the Act will have to be applied to me and to the person who is taking my data. Now, the second aspect, whether Shivram, who is a citizen of US, sitting there trying to avail a product which is in India using his PAN card at the moment? The answer is yes, still that application would be effective, even if that company which is located in US. Now, these are the broad aspects how the applicability and the scope would continue in the Act. Yes, there will be a lot of deliberations in the use cases in the coming months, where it can happen that, yes, this is the problem faced by a particular company. How would I be able to source the data? How I am going to go? So there are a lot of deliberations which might happen, though the government has made a very categorically phased-wise manner. Yes, the implementation is required to be done in a staggered manner. It cannot happen on just one act has come and everything is to be started from tomorrow. So it's a very thoughtful process. One, as a user, I will also have certain roles and responsibility to kept in mind. So it's just not that the user is only going to be the person who is to be considered. It is the fiduciary persons who is going to collect the data as well. So the board focus is on both sides. It's not just one person. So with that thing in our mind, we have considered, let us assume whether this act can be followed in this scenario one, right? Now let's say Arun, who wants to open a bank account with a bank you called Eurobank. He shares his ID proof with a compliance consultant who's going to forward it to the bank for a video-based KYC verification. Now, since the act, that is the definition, has already been effective, now whether this provisions of the act is going to apply and what are the persons who will be identified in this. Now, in this case, Arun will become data principal because his data, right? Then, who is the data fiduciary? That's a definition given, right? Now, data fiduciary will be the bank. Data processor, who will be data processor, is the person that's the compliance consultant who's going to process on behalf of the bank. Let's assume a second scenario, right? Whether the act is going to apply or not. Reena, a travel blogger, publicly posts her personal details, including her age and phone number, on social media profile. A follower calls her. What remedy does Reena have? And can she take a defense that the caller who has called her is infringing her privacy rights? The answer to this question is no, because she has voluntarily and publicly made her information on record. So the act is not going to apply, or no remedies can be availed except if there's a civil case which she might like to do it. But under the act, she will not be able to take any defense. Moving forward, let's understand, as I said, who is a data fiduciary or who is a data principal or who is a data processor. Let's have because these provisions will be effective within 12 months from the act which is notified. So by 2026, one has to make sure that the data principal, the data fiduciary, the roles and responsibility to each and every one of us have been categorically been framed. Now, if what are my rights as a data principal, what is the right which I will have? I will have the right to information, that is, what information that the data fiduciary has about me, what correction should I want to make into it. I will always have the redressal mechanisms if there is something wrong or misuse of my data done by the data fiduciary. Now, what is my obligation? I cannot just like Reena, I cannot just say just a guy who called me, and I cannot be furious in nature. Or I would say the number which is displayed by Reena is not her own, but it is her father's number. So again, the authentication of the information which I provide has to be authentic. I cannot say XYZ is my number. If it is my identification number, I am able to do it. That's what my obligation would be. Mind, there is also a provision against the data principles. There are a lot of people, a lot of public comments which talks about what happens to company because there's a heavy penalty which is imposed upon the companies. please mind, even if you share a wrong information to someone, even a principal is also liable for certain, though it's not high as to be given to a fiduciary, but I am still liable to pay certain penalties under the act. Now, what is a data fiduciary? It is the purpose for which the information is sought for, with, and it has to be always in personal in nature. Please mind that it is a personal data. It cannot be, say, a bank is asking the document of a company, and whether that document of the company can be considered as a personal data. The answer is no. The mechanism is, it's for the purpose of the individual, that is the data principle. Now, how would and what is the roles, what is the duties of the data fiduciary? He has to freely obtain the notice, has to be informed, consent. Notice, I'll come to it because there is a certain provision which I have made it in the coming slides, which will make sure that how this notice, this requirement will come. Now, this information which I'm going to collect, is this the safeguard of this information, I'm going to keep it, the security behind. What happens if there is a breach in this, or maybe say there is some cyber attack happened on the company, and all this information is gone to a third person. So what is that remedies I am going to put? And there is an obligation on the fiduciary to provide this information within 72 hours. So there is a lot of responsibility on the data fiduciary to make sure that the data which has been obtained is not for a lot of, say it is for an n number of years, it is only for a limited purpose, taken an adequate consent, and that consent has a specific purpose. Once the purpose is over, the data is been deleted, or whether it is should not be retained for a lifetime. Now, as data fiduciary has so much of documents, maybe there are a lot of things to consider it. He might obtain a third party to process this data. So that is called a data processor, who will, on behalf of the data fiduciary, will collect or process these personal information of the data principal under a contractual obligation. Now, there is two school of thought which says he should be equally be liable if there is a breach from his end. Now, when you read the act and the rules, it is categorically distinguished between the two. It might happen that the data processor might himself be the data fiduciary, but it cannot happen that data fiduciary is a data processor. So both ways it can go. It might happen I am delegating this power to someone and the data is only for myself. But the other way around, that the processor can always become a data fiduciary, but can always never be a same guy. So please understand that kind of a arrangement which will require to be kept in mind. Considering this distinction, what we have asked, let me put this question to the participants. Say Ria, an individual, had already given her consent while shopping in a shopping platform that is called ShopX. Now, certain provisions, as I said, that Section 2 of the Act has already been implemented. Whether the information which is collected, what is the obligations on ShopX? So the question which I like to ask the participant is, after the commencement of the DPDP Act, what is ShopX required to do in respect of RIA's previously collected personal data? So the options which I will like is to state, say A, delete all the previously collected personal data and request fresh consent. Second, immediately stop processing the data till RIA gives new consent under the Act. C, provide RIA information describing the personal data being processed and the purpose for such processes. Or D, transfer RIA's data to a consent manager before continuing the process. I like to take a 30 seconds more kind of a thing and expect certain answers from the audience. All right. Right. So Ankit has given one answer. Let's see if it is right or wrong. Now, the answer I would say is C, because there is now a provision under the rules within a period of 12 months. Yes, it will have certain implications how these platforms are going to make the notice which requirement is required to be taken. So the answer to the explanation is yes, as soon as the word or the rule has been said as soon as practical, right? So that means now we have known that 12 months is the period where I will have to take the information and the notice is required to be given. It can be by way of an email or maybe an in-app, notification giving her consent, but it cannot go through a privacy policy which we are currently using it. So that has to be kept in mind. It cannot be already a mechanism. Yes, I have already given in my website. Can you please continue with that thing? And no, the answer is no. The Act's requirement is it is to be separate with the existing mechanisms. Yes, there is no model at the moment. A lot of questions which I have been asked offline is what is the format of this notices which I'm required to be given. At the moment, there is no format prescribed. We might expect in the coming days or in the coming months that the board, once it is formulated and all, they might give a guidelines on the certain model kind of a notice which will require to be published, though it cannot be a copy paste which might be used. But please understand this act is on the creativity of how you're going to take the consent, right? It might happen that the model which might be prescribed may not be suitable for you. So you will have to be in a creative manner to understand what kind of the use you are going to take. There might be a tick box, yes, 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 no, no, no kind of a thing, or maybe like a click wrap in what we use to state continue and use the platform ahead. So we'll have to be very creative. The founders and the startups would have to be very creative in that manner, how to take this consents. We'll have to figure it out in the coming year, right? Now let's take one more example. This is again pertaining to who will be the data principal, who will be the data fiduciary, and who will be the data processor. The question here I would like to put is this wise is India Connect Private Limited is a subsidiary of a US-based Global Well Inc., right, which operates a social media platform in India. So here it means who is data principal? I will be the data principal. You as a user will be the data principal. It is the individual people who will be the data principals. Please understand, a lot of people will have this question, why is not Global Wave considered to be a data fiduciary, right? The answer is, I'll come to the answer later on, but the logical or what the data is being used or who is data being processed is to be considered. Hence, uh, IndieConnect will be considered to be the data fiduciary. Now, who will be the processor? Maybe some cloud storage which the client or which IndieConnect is going to use to store the data. He will become the data processor. And we might see that the responsibility or roles is independent in such situations, right? In that case, only it will become that IndieConnect will be the data fiduciary. Assuming this question is reversed, stating that they are connected, the information will be used by Global Wave, then in that case, IndieConnect and Global Wave both will become the data fiduciary. So with that conceptual clarity, we will now get into certain new nuance which has never been in the world. That is the consent manager, which is morely given control only in the DPDP Act. So what is and who is a consent manager? When the draft rules and the deliberations were going on, there was a lot of confusion whether it will be an individual, whether it will be a bodies corporate. And now after the finalization of the final rules which is in effect, it is very categorically stated and indeed it is not an individual, it is going to be a bodies corporate, it is going to be a person who is a bodies corporate who is minimum capital requirement will be 2 CR. So, and there's another question which always been followed up with this uh, is it necessary for any data fiduciary guy to always have a consent manager? And this consent manager will actually have to be regulator or get a registration from the board. The answer to that question for a lot of people, I'll like to put it on record is if you have an in-house consent manager, it can still work. There is no problem that you have to go explicitly asking for a third party. The mechanism provided under the Act is two ways. Either you have your in-house, you have the adequate measures, infrastructure, facilities, secure the rights and everything, then it is okay. If you are unable to do it, go and take this services from this consent manager who has been registered with the board. And what will he do? What is his roles and responsibility with the data is given by the data principles? So what he will do is he will give the data, take the consent from the data principle, manage it, review it, and also see if that data has been withdrawn by the data principle. He promptly informs the same to the data fiduciary that the consents had been withdrawn. You have no right to use this data anymore. To illustrate this, I have made an example to consider. Now we will like to see what is this example. Let's read together. That is, Radhika uses My Data Safe to control her data consents, right? It's an app which she is currently using. When she signs up for a Meditech platform, say Health Plus, she chooses her consent through My Data Safe instead of directly putting it on her app, right? With that is particular app. Data Plus sends this detailed consent request to My Data Safe, specifying the purpose of processing Radhika's personal data for teleconsultation, right? Now, My Data Safe displays this notice in a very clear standardized format, which she will have to approve it. Then the consent manager will send this verified consent verification to Health Plus. Radhika can later on, if she wants to withdraw this will have to be done, right? So this is what the practical approach will happen in the years. It might not happen that I can simply log into a particular app, use it, and just click on a click wrap thing and continue using it. It cannot happen. So I have to know what, and the best part of this is in India, we have 22 languages as considered to be the official languages in India as per the constitution. So this notices which are required to be said will require to be displayed in all the 22 languages in which I as a user would be comfortable in answering the questions. It cannot be a simple click grab. Please understand that I need to be informed prior my information given to anyone, right? Therefore, in this case, who will become what is the question I like to put. My Data Safe will become the data consent manager who will be ultimately be registered with the board, assuming My Data Safe manager will have that net worth of 2 CR and is registered. If he is not using it, then obviously My Data Safe is not the particular guy where you can store the data. Now, this example can also be modified, stating that Health Plus has its own internal data security mechanisms to take consents. If that is being used, she is not going to avail the services. That's been very simple. We have considered My Data Safe is having that adequate mechanism or the adequate net worth certificate, which he is 2 CR and has got the registration, which will happen all ultimately in about 12 to 18 months' time with the detailed framework given by the government. There's one interesting aspect of relationships of the act has given really great weightage to children and disabled people. So the assuming that Rohan is a 12-year kid who wants to use, because we are all in that internet phase, technology platforms, studying materials, everything is on tech platform using things. Whether now there will be a change to it, yes, there has to be a lot of changes. My target audience as a business owner cannot be Rohan, who is now 12, right? The Indian laws have very categorically said a person who is less than 18 is a minor. They are not capable to enter into contract. So no information pertaining to him or her cannot be also be taken, whether with her consent or otherwise. Let's put this wise, right? If it is a less than 18 months year old minor kind of a person who wants to do it, the act has given certain provisions how the same is required to be done. Section 9 of the act talks about that the legal guardian or the parent will have to give the consent, and the information which is passed off about the minor cannot be tracked. The thing which I started with my conversation, that data, something happens, everything comes back in my feeds of my all wherever I go. So that is the requirement. You cannot have the data to be monitored for a minor. And the same goes with the disabled person. The one interesting aspect which we miss in that is what about senior aged people, say my mother, father, who is about 70, 75 age. The act is at the moment missed in it. Maybe in the coming years, we might see that there is certain modification to this rule also. Maybe the elder persons who are considered maybe as a senior citizen people who are unable to read and all, maybe there is some different mechanisms for them to also see it. Maybe we will be able to see it in the forthcoming years. We are not sure on the use cases now, but yes, we will see that in the coming years. What happens if there is a data breach, right? Say my data was used, or say it has been by cyber theft, all data has been lost by that company. So the first and the foremost thing is you have to speak to that person, get satisfied if that resolution has happened. Obviously, I am not considering the dispute in terms of monetary value. Obviously, the damage has been caused. The irreparable loss, which is of my information, is gone. I can only take preventive measures of not further giving it to expose it. There is no monetary gain in this kind of laws. Please understand very categorically that I cannot claim the damages pertaining to the information which is gone. I can only be in a preventive measure. Say the every mechanism which is adopted in by setting up failed, the grievance officer did not give me the right advice or did not stop the data further be destroyed. What happens? I will escalate to the board, which is now ineffective. Obviously, the board is yet to make its formal constitution and all. Yes, once the board is there, the board will make sure that the investigation is done. The framework given is certain timelines. Obviously, it is what we see it at the moment is everything is going to be online. So if my data has been lost from say Bangalore and the company which is sitting in say in Kolkata, and we are knowing that the board might be sitting in New Delhi. So I don't have to personally go and visit to Delhi and make this. So there is going to be an online platform where this mechanisms will be taken place. What happens if the board also you failed in front of the board the present the case and you lost the case? Yes, appeal provisions have been given, or maybe the other side says no, there was no data breach from their end, and the appeal provisions have been given to the appellate tribunal and then Supreme Court. So there's a lot of compliance where you can actually fight it. But please understand, the loss of damage is a loss of damage. The data which is lost is a loss of damage, right? You just have to take it preventively, close down, and the alternative method which is given in the act is to make adherence to the alternative dispute resolutions. So rather going into the litigation side, better to resolve and stop the infusion of further damage of the data. Yes, the most impactful thing, and a lot of people talk about, is the 250 CR or the 200 CRs penalty imposed. Uh, See, this is the maximum cap which they have given. It is not that if I make a breach, I will be directly being infused with a maximum penalty. So the board will consider the grievances, the type of offense and all. There's a lot of provision relating to it. I will not get into it because there's too much of time I might be taking it. This is just on the practical side, which I don't want to put, but I will like to come to the main agenda, that is the principles of the GDPR, right? So there are 7 principles to put this: lawfulness, fairness, transparency, purpose, data minimization, accuracy, data storage, integrity, confidentiality, and accountability. Uh, the EU is using this, and now they are coming up with the act of the AI. What India is doing is reverse. We have, last year there are a lot of fundings on the AIs and everything happened. And this year we have started the rules. So we are adopting a reverse mechanism. So when we compare with the GDPR and India, we might have an upper hand. We might see it because we know what has happened in the AI ecosystems and all. The funding is happening, how the data is going and all. And now with the implementation of the act and the rules, we're able to make a balanced situation so that the development of the AI and the startups are going in one side, and the data which is required to be secured while utilizing such things is to make it. So my take on that would be whether the alignment is there or not. Obviously, we are actually seeing there are a lot of alignment there in per se, but there is a major distinction is that India is going to be the consent oriented and the people oriented first, rather making machines as power, right? So we are not going to be in the reverse order. We would see it center is going to be the data of the data principle, and it will be more in his importance. So the framework will have to be considered that wise. One major distinction which is there is the data profiling thing, which we are sure in the coming couple of months we will be able to cure that defect also. With that, my last slide, I would like to keep it is time is essence. 12 months or 18 months, whether it is going to be completely be able to conclude everything, I'm not very sure of it. So the time is going to be the main factor. So we'll have to keep there is a transparency or start using technology or make certain provisions now itself. So at the last or the 11th hour, we are not missing out the primary focus on it, right? The second, improve your structures, consider what are the mechanisms which you like to take in the next 12 to 18 months time. Are you getting in line with the DPDP Act? People are not going to say that 2 साल पहले आ गया है तो अभी तो ठीक है, we still have 18 months time. The act has now taken at least 2 years time. So you cannot take this excuse कि I still have to make an improvement in it. You are given sufficient time enough to improve your mechanisms, identify it, and make alignment with your objectives. Monitor, that's the main thing. Once you have, if you have collected the data, let's be very sure that there is no data leakage happening or a data theft happening. If there is happened, if there is a cyber attack on the systems of your organization, make sure what are the recourse you're going to take it. Have you informed the data principal about it? Keep on monitoring. Monitoring is very key in this regulation. And the last, have effectiveness in your in your mechanism safeguarding, and there's no breach, and the access is limited to the purpose when you want it. With that concluding marks, I'll give back to Jashaswee. Thank you.
Um, Thank you for your insights, for providing us an exposure and perspective to the overview of the DPDP Act and rules. Now I invite Mr. Kapoor to the floor to address us with the practical implications of the Act. Please, sir.
Hi, thank you. Thank you so much. Thank you, Shivram, sir, for that excellent, very comprehensive walkthrough of India's evolving data protection landscape. I think your overview makes one thing clear. The DPDP Act, together with the newly notified rules, is no longer just a conceptual framework. It's a functioning, enforceable structure that organizations now need to operationalize. The last thing I heard talking about that improvement statement, ki, we need to operationalize this particular thing. I remember last year I went on this startup group. So they asked me like when will the DPDP Act will come and how we have to do this and what to do this. So my first answer to them was ki, know what your data is, what is your data, where it is going, who all has access to it and everything. So they told me कि सर अभी करने का क्या फायदा है, अभी तो बहुत टाइम है, अभी तो I mean like DPDP is not in the terms, like it's not coming right now and everything. And now again I got a call from that particular same guy, and he was saying, sir अब तो आ गया है, अब क्या करना है. I I actually told him the same thing that I told you that 1 year before कि improvement तो लगेगी, and you need to know what all data, what all everything you have, and you need to know that particular thing. So on that note, building on that foundation you have said, what I like to do is now to take the conversation global, and specifically by placing India's DPDP framework side by side with EU's GDPR. I'll share my screen and yes, just give me a moment. Yeah, right. Are you able to see my screen?
Yes.
Yeah, right. So, right. So first, purpose and philosophy. What I have in my mind is that at a principal level, both laws share the same North Star, empowering individuals and ensuring organization processes personal data responsibility. GDPR is built on the well-known principles of lawfulness, fairness, transparency, purpose limitation, minimization, accuracy, storage limitation, and accountability. On the other hand, DPDP, while not using the exact same terminology, enforces these principles through obligations on data fiduciaries, such as purpose specification, consent-centric processing, security safeguards, and grievance redressal. For example, I'll talk about the first comparison, which is scope definitions and architecture of DPDP versus the GDPR, wherein under Section 3 of the DPDP Act, the law applies to processing of digital personal data within the India and to processing outside India where it is in connection with offering goods or services to data principals in India, while carving out personal or domestic use and data made publicly available by the data principal or under a legal obligation, where you mentioned Section 2, the data fiduciary, which is equivalent to the data controller, and the data subject, which is the data principal, and the data processor is exactly the same, the data processor for DPDP and GDPR. And on that note, by comparison, there's a similarity in both of these GDPR and DPDP, where the GDPR applies to any processing of personal data wholly or partly by automated means and to manual data that forms part of filing system. This is the common aspect of both of these, that they have this digital plus structured offline data, which covers which both the acts covers. On institutional and architectural level, the DPDP Act creates the Data Protection Board of India under Chapter 5, a centralized quasi-judicial body functioning largely through a digital office, while on the other hand, GDPR relies on independent national supervisory authorities and the European Data Protection Board for consistency across member states. So you'll see 27 supervisory authorities, 27 to 30 supervisory authorities are already there, which are for the member states, and one main body, which is the European Data Protection Board. The DPDP rules 2025 further clarify that the Data Protection Board will operate via online platforms and mobile applications with 4 members appointed by MeitY and a focus on accessible tech-enabled redress, which is structurally different from many European DPAs. Second of all, I'll come on legal basis for processing. So the consent part, which is the most important part for the DPDP Act, where in comparison with GDPR. So Section 4 of the DPDP Act is deliberately simple. Processing of personal data must be for a lawful purpose and may be carried out either on the basis of consent or for certain legitimate use, which is listed in Section 7. These are the Section 7 legitimated use: state functions, emergencies, employment, subsidies, and legal obligations. So they are exhaustive in nature, whereas in comparison with GDPR, so one of these have 6 legal bases, which is legitimate interest, contractual needs, and legal obligations, vital interest, and public task. Section 6 then defines content, or Section 6 of DPDP Act defines consent as free, specific, informed, unconditional, unambiguous, given by clear affirmative action, and limited to what is necessary for the specified purpose, which closely echoes the consent standard under the GDPR. However, the certain legitimate uses in Section 7 cover, among others, state functions and subsidies, compliance with judgments and legal obligations, responding to medical emergencies or public threats, disaster management, and certain employment-related processing to prevent loss or protect confidentiality and trade secrets. From a practical perspective, that means Indian organizations will very often lean on consent, supplemented by specific statutory or public interest grounds, whereas under the GDPR, many controllers default to contractual necessity or legitimate interest instead of consent where appropriate. It also means the global organizations cannot simply copy-paste GDPR legitimate interest assessments into India, because DPDP compliance hinges on checking whether the use falls within Section 7, which is a certain legitimate use, or truly requires consent under Section 4 and 6. Next comparison, I would like to go on rights and transparency of transparency and data principal rights. So Section 5 obliges data fiduciaries to provide a notice with details of the personal data being processed, the purpose, the manner of exercising rights under Section 4, subclause 4, Section 6, subclause 4 and 13, and how to complain to the board with the option of data principal to access the notice in English or any 8 scheduled language. So the DPDP rules 2025 build on this by requiring clear and separate consent notices, simple language, and practical accessible mechanisms for withdrawal and complaints, aligning in with spirit with the GDPR's transparency obligations under its Article 12 and 14. The GDPR Act grants 4 core rights to the data principal, which are access to a summary of a personal data and processing activities, information on sharing, a right to correction completion, updating and erasure, a right to grievance redressal, and a right to nominate another individual in case of death and incapacity. By contrast, the GDPR provides a broader bouquet of rights, including access, rectification, erasure, portability, restriction, objection, profiling, automated decision rights. Another distinctive feature which I liked the most about is of the DPDP Act is the Section 15, which imposes explicit duties on the data principal, such as not impersonating others, not suppressing material information for identity documents, and not filing false or frivolous complaints, which also has a penalty of rupees 10,000 or violations. The GDPR, by comparison, does not impose codified duties on data subjects in the same way, focusing instead on controller and processor obligations, which underscores a more reciprocal responsibility sharing model in the Indian statute. Next, the comparison would be on children's data and age thresholds. So in children's data is an area where India has chosen a relatively strict position. Section 9 defines a child as anyone under 18 years and requires verifiable personal parental consent before processing a child's personal data or that of a person with disability who has a lawful guardian with restrictions on processing likely to cause detrimental effects on the child's well-being. It also prohibits tracking, behavioral monitoring, and targeted advertising directed at children. which subject to limited exemptions and future relaxations where the government is satisfied that the processing is verifiably safe. And under the GDPR, the default threshold for the child age consent in relation to information security services is 16. But they have given a different, a more linear option, which the organizations can lower it to 13 for the age of children. And there is no blanket prohibition on targeted advertising to children. So that is the most important in terms of DPDP, where the government has made sure that this particular targeted advertisement directed at children is will be monitored and will be prohibited. This means that in India, organizations dealing in edtech, gaming, social media, or youth-oriented services must treat anyone under 18 as a child for DPDP purposes and rethink about profiling and ad tech practices and design strong parental consent and age assurances processes. It also suggests that entities harmonizing with GDPR's lower age thresholds will need a highest common denominator strategy, or at least India-specific age gating and consent flows for under 18s. Next comparison would be the broader cross-border transfers, the cross-border transfers of the data. Another crucial point of diversion is cross-border transfers. Section 16 of the DPDP Act authorizes the central government to restrict transfers of personal data by a data fiduciary to such countries or territories outside India as may be notified, effectively creating a driven negative list, or which it will be called as a blacklist, which the government will notify that this particular countries or this particular areas will, I mean, specifically countries, we will not have a cross-border transfers of data. And unlike the GDPR, which specifically deals in SCCs and BCRs. What are SCCs? It's a standard contractual clauses or a binding corporate rules which are done between the countries for specific transfer tools, and it gives principal freely transferable except to blacklist jurisdictions. So the comparative analysis emphasizes that GDPR model is more granular. It relies on adequacy decisions, safeguards like SCCs and BCRs, and derogations in Article 44 and 49, making cross-border compliance highly documentation heavy and risk assessed. The DPDP rules and subsequent guidance also indicate the possibility of additional localization, like requirements for certain categories of personal data processed by significant data fiduciaries, even if the primary act itself is relatively liberal or transverse. Practically, multinationals will have GDPR-style transfer agreements in place globally and will now need to overlay DPDP-specific checks, whether the destination country is on India's restricted list and whether any sectoral regulator has imposed stricter localization. Last, I would come on the governance, enforcement, and penalties. Section 8 sets out the general obligations for data fiduciaries, including ensuring accuracy where data is used to make decisions or shared, implementing appropriate technical and organizational measures, adopting reasonable safeguards and security safeguards, and notifying the board and effective data principles in the event of personal data breach. Significant data fiduciaries designated under Section 10 based on volume and sensitivity of data and risk to rights, democracy, and state security must appoint a data protection officer in India, engage an independent data auditor, conduct periodic data protection impact assessment and audits. This is specifically for SDFs, the significant data fiduciary, which the companies will know when they'll deal with how much data they are handling and what kind of data they are handling. Like for example, for the data protection impact assessment, that is necessary for the organization to know whether they are handling PIIs or sensitive personal data. So in terms of penalties, the schedule of the DPDP Act summarized by PRS and others allows the board to impose monetary penalties up to 200 crores for non-fulfillment of children's data obligations and up to 250 crores for failure to implement reasonable security safeguards to prevent data breaches with no aggregate cap per incident. By contrast, GDPR's enforcement regime follows fine up to the higher of 20 million euros or 4% of global annual turnover alongside corrective orders, bans on processing and reputational impacts, which in practice has created a strong culture of regulatory engagement and case law. Indian commentary notes that while DPDP monetary caps are lower than the GDPRs, I don't say it's lower, it would be equal, more or less. But GDPR do have a 4% of global annual turnover that would amount to significantly more than the DPDP's penalties. The Act focuses on mandatory breach reporting and the board's wide inquiry powers, coupled with sectoral and certain collaborations, while likely create a strong enforcement environment in 2025 and beyond. So the DPDP 2023 takes a compact principle-driven approach, while GDPR offers comprehensive multi-layered protections with extensive legal base and controller flexibility. This is the architectural difference: DPDP compact framework, GDPR comprehensive system. Both have the digital personal data and structured offline data processing. Fewer legal bases, 6 legal bases with flexibility. Principle-driven approach, risk-based, multi-layered. Data protection board, which will be a digital office. And on the other hand, GDPR has 27 to 30 supervisory authorities plus a European data protection board. And last point would be the blacklist for transfer, which is for cross-border transfers. And for GDPR, there are adequacy decisions, there are standard contractual clauses, there are binding corporate rules. So this is the regulatory landscape, the DPDP Act, and for the GDPR. Last, I would like to start with the DPDP compliance framework, which I have fulfilled in 6 pillars for data protection excellence. First, yeah, just give me a moment. Yeah, so the pillar 1, which is governance and classification. So first part is for the companies to know, every organization should begin by mapping whether it is a data fiduciary or also likely to be notified as a significant data fiduciary based on volume and sensitivity of data and risk factors listed in section 10. Because SDF, the significant data fiduciary, the organization would status would trigger DPO, DPI, and audit obligations. DPDP focused industry guidance for 2025 emphasizes that many mid-sized fintech and edtech players alongside big techs are likely to be designated as SDFs as the regime matures. So treating SDF level controls as a target of operating model is prudent. Organizations should establish or adapt privacy governance forums similar to GDPR steering committees to oversee DPDP implementation reporting to board or equivalent, which also aligns with the DPDP requirements that the DPO be responsible to the governing body. Next, data mapping and DPI, the pillar 2. Even though the DPDP Act does not explicitly copy the GDPR's Article 30 record of processing format, India and international advisors consistently recommended comprehensive data mapping as a foundational step covering data flows, purpose, legal basis, and sharing. This exercise feeds directly into the data protection impact assessment, which is also referred in GDPR as ROPA, record of processing activities. That particular thing for GDPR, it automatically gets into the data protection impact assessment for GDPR, which is required for the organizations which are categorized as significant data fiduciaries for the DPDP Act. So this exercise feed directly in the data protection impact assessment required for significant data fiduciaries under Section 10 and the DPDP rules, which must describe the processing, assess, and manage risk to data principal rights and document mitigation measures. Given the rules emphasize on the annual DPIAs and independent audits, organizations should standardize DPI templates and risk scoring that can serve both DPDP and GDPR, inserting India-specific questions on certain legitimate uses, localization risk, and negative list transfers. Next, the pillar 3, the notice, consent, and withdrawal. Under Section 5 and 6, the DPDP Rules 2025, the data fiduciaries must provide clear, specific notice, obtain consent that is free, specific, informed, unconditional, and unambiguous, and ensure withdrawal is as easy as giving consent, including via registered consent managers. The rules require separate consent notices explaining the specific purposes and linking to rights and grievances mechanisms with language options, including English and the 8 scheduled languages, which has UX and localization implications for Indians facing services. For organizations already following GDPR, this is an opportunity to rationalize consents, avoid bundled or vague purposes, and to ensure that where they rely on DPDP certain legitimate uses instead of consent, that this is clearly recorded and explained in the notice. In consumer-facing context, building intuitive dashboards for consent management, mirroring GDPR-style preference centers, but integrate with GDPR India registered consent managers while likely become a key differentiator in becoming accountability to the board. Fourth, the pillar 4, rights and grievance redressal, which is data principal rights. The DPDP Act requires data fiduciaries to provide mechanisms for data principals to exercise their rights to access, correction, updating, erasure, and nomination, and to handle grievance before the matter escalates to the board. Rules and commentary in 2025 indicate that timelines will be prescribed for responding to grievances and rights requests, and that the board expect digital trackable workflows, much like supervisory authorities assessing GDPR compliant right portals. Next, I would come to the security breach and third-party management, which is also the pillar 5, and also the most important, what I think, in terms of vendor management, which is Section 8, which requires reasonable security safeguards, which is for the penalties, which can go up to 250 crores. And for third-party risk, Section 8.2, clause 2, explicitly requires that processing by data processors be under valid contracts, while industry commentary stresses the need to update vendor contracts to include DPDP-specific clauses on security, sub-processing, audits, and cross-border transfers. Cross-border organizations should track any negative listed countries under Section 16, which will be defined by the government, and where they are also subject to GDPR layers, SCCs or BCRs on top, so that both European safeguard and India's country restriction model are addressed in a single transfer framework. For high risk or SDF level processing for significant data fiduciaries, the DPDP rules focus on assessing algorithmic impacts, suggesting building governance around AI and automated decision making, including model risk assessments and explainability, even though the DPDP Act itself does not yet codify detailed AI provisions. Last is the culture and highest common denominator design, which is the DPDP framework rests on principles of consent and transparency, purpose limitation, data minimization, accuracy, storage limitation, security safeguards, and accountability as highlighted in official and industry analysis. Compliances guidance for 2025 repeatedly frames DPDP as shifting privacy from a policy document to a core business function, urging organizations, particularly startups and digital first businesses, to treat privacy governance as a strategic asset rather than a box ticking exercise. For entities subject to DPDP and GDPR, the most sustainable model is the highest common denominator approach. What is that? Design global processes to meet the stricter of the two regimes on issues like consent quality, security controls, DPIS, and DPIS data protection impact assessments, and vendors due diligence, and then dial in local specific where required. This reduces fragmentation, helps avoid inconsistent treatment of data principles in different geographies, and makes it easier to demonstrate accountability for both European supervisory authorities and the Indian data protection board. So at last, I would like to conclude that India's DPDP Act and DPDP rules are clearly inspired by global standards like GDPR, but they are not a copy paste. They reflect India's digital priorities, regulatory style, and risk allocation choices. For in-house teams, councils, and founders, the task over the next 18 months or 12 months is to move from theoretical awareness to operational readiness, which is data maps, DPIAs, consent flows, contracts, and incident playbooks, which, if done thoughtfully, can both satisfy regulatory and build trust with users. In that sense, alignment with GDPR is not just about ticking two legal boxes. It is about using the common principles of transparency, accountability, and rights protection to design a resilient, future-proof data governance framework for India's digital economy. Right. Yeah, so this is the compliance requirements and the best practices, which I just mentioned. Any questions?
Thank you, Mr. Kapoor, for your insights on the practical implications of the Act and for providing us with the compliances that we require. So before we close, I would like to take a moment to address the most critical takeaways from this session. Uh, the most fundamental takeaway, what we understood is that we are considering people first and technology second, as been stated by Mr. Ganesan. Now, there's a gradual power shift to all the individuals involved. That is, for all the data fiduciaries, data principals, and data processors, there are certain sets of rules and regulations, obligations, and liabilities for all now. As been stated by Mr. Kapoor in the beginning, we must know where our data is and what is our data. This act also introduces the accountabilities and penalties and asks us to ensure that the data minimization happens. Before conclusion, I would like to take up the questions that are there in the chat box. So there's a question for Mr. Kapoor, which says, does the DPDP Act impose any obligations on data principal regarding consent management, withdrawal mechanisms, or data access required? Or is the compliance burden entirely on the data fiduciaries at this stage? I would like to direct this question to Mr. Kapoor. Would you like to answer, please?
Yeah, right. So, particularly, like for example, data principle, there are three things that are towards the data principles, which is which one is the uh, just give me a moment. I'll just yeah. So yeah, so the three things which the data principle that the DPTP Act has mentioned, that for the data principles is that first is the impersonation, and second is materially giving not I mean not
Misinformation.
yeah. I'll just sorry for that.
No.
Right. Yeah. So that was the truthfulness, non-impersonation, and frivolous complaints. So whatever the organization requires, the material, the things, the data principle cannot take back, that they have to produce that particular documents if they are asked from in the terms of consent management, or in terms of when there are mandatory, or if the government have that certain legitimate uses cases, the data principle has to have provide that particular thing, or that would go towards a fine of rupees 10,000 for that violation.
Thank you, sir. I hope that answered the questions. We have another question from Mr. Goel, who I believe is a startup founder. He asked that he wants to know that if suppose he has collected personal data in a Xerox form, then the company also whether the company then also needs to comply with the act. I would like to direct this question to Mr. Ganesan. So would you like to take up this question, please?
So when you read section 3, I mean, which is going to be effective from 12 months, it only talks about digitalize, right? If this Xerox is in a printed form, we are assuming he's taken it from the data principle in a printed form, then the act is not going to applicable for Mr. Goyal. For a moment, if we consider the Xerox copy which he has taken and is going to store in his data, I mean, that is some device which he is going to create in his own office. When the Xerox copy has been digitalized, then definitely this act is going to be effective. And this will have its own repercussions on maintaining everything. The entire responsibility of being the data fiduciary will applicable to him after 12 months, but he should adhere. If he is taking it on Xerox, there is no need. But if he is going to digitalize the same, start making the adherence to the law, get it more effectively, how you're going to make these things forward and all that kind of situations. Oh, it answers Mr. Goyal.
Right, sir. Right. So there's another follow-up question. It says, hope everything goes well with the compliances. So Mr. Kapoor, would you like to address what are the compliances required for a startup?
Right. So first, what I said, know your data. So every compliance program, whether GDPR or DPDP, begins with a simple question: what data do we have? What do we collect? Where it goes? And who uses it and why? This is the first inventory for any organization. Second is updating privacy and consent, which is this simultaneously going part. But the third and the fourth part are the most important things, where when we are dealing with when we are mapping our data, which is strengthening technical and organization controls and vendor contracts. Why vendor contracts are necessary? Because in an organization, the vendors are the most important vendors are the most important area, where our data is also going to that particular vendor, and how they are processing that data, that is a very need to know basis, that whether they are aligned with specific standards. So for example, ISO or GDPR, they're aligned with that particular things. These 3 to 4 and strengthening our own organization technical and organization controls. What controls do we apply? What encryption do we have while the data is in transit? or at rest. So these 4 steps are very important for the first. And the fifth and sixth steps are the establishing a breach response plan or an incident response plan, where if anything goes wrong, where if anything, for example, there's a vendor Cloudflare. If you know about it, there was a news that yesterday and day before yesterday, it was their services was hampered. So around 1.5 to 2 hours, the Cloudflare services were hampered, and due to which what I felt was ChatGPT and certain other technical organizations had gone disrupted their services for that particular moment. So I actually believe that incident breach plan and incident response plan is also an important aspect. And last, of course, the awareness, the governance, and the training and culture of your organization. Hope this answers.
Mr. Kapoor, there's another question. They are asking, Mr. Goyal is asking, is there any certification required as of now?
So, right, it depends. First, of course, it depends on the organization first, like what kind of organization we are in and what kind of data we are dealing with. And second, according to DPDP, we need to know whether we are data fiduciaries or significant data fiduciaries, right? And of course, standards required basic if we are in India and setting up and dealing not specifically with Indian residents, also US and everywhere. So ISO is the basic standard, which 27001, 27701 for information security management. And of course, the NIST framework for cybersecurity, for all of the cybersecurity controls and technical organizations and measures.
Thank you so much. Though we have received multiple questions, but there's a paucity of time, so I would like to conclude the session. On that final note, thank you everyone for joining us, for having this interactive session. I would like to thank all the speakers, Mr. Ganesan and Mr. Kapoor, for having patience, for answering to all the questions, and for providing us with the perspective on the DPDP Act and rule. As both the speakers have stated, there are certain gray areas, so I believe that there would be some developmental updates that would come in the nearer future. When the updates come, we shall schedule our forthcoming webinars accordingly and shall meet very soon. Thank you, viewers, for all your patience, for your time, and for participation. I believe that you had a great time. Thank you.
Thank you. Thank you.
Thank you. Thank you so much.
Right.
As India Juris, we aim to be the best place for the lawyers to work in and set up standards for the lawyers to develop their skills being in this law firm. We aim to provide high standard of international legal services to our international, global and domestic clients.
India Juris is having innovative strategies with regard to intellectual property rights disputes as well as international dispute resolution. And we are having a lot of milestones which we have achieved and about to achieve.
At India Juris, as a full-fledged law firm, we are advising corporates, startups for their advice on IPOs and further transactional matters.